Welcome back everyone to the Sharma Academy. Today we are gonna discuss about the indemnity, the contract of indemnity that is very important from the exam point of view. At least 2 marks. Okay, at least 2 marks in the legal exam would be asked from this chapter. Okay, so let me first explain the what is indemnity. Okay, indemnity means to make the losses good. To make the losses good. Okay. So for an example, in banks we regularly come to face such kind of problems when a person, suppose Mr. X, okay, suppose Mr. X comes to the bank. Mr. X is the customer of our bank. Is the customer of the bank. Here is the bank, okay. So Mr. X lost his FDR, lost his FD, fixed deposit receipt, okay. Then he comes to the bank for a issue of duplicate FDR. Okay. So in that case, bank asks the customer to provide the indemnity bond. Okay. In which it is written that Mr. X, Mr. X has lost his original fixed deposit receipt and he is the true owner of that fixed deposit account. If any claim is made by any third party against that FD, that particular fixed deposit account, Mr. X will compensate the losses that the bank will face by any third person. Okay. So Mr. X will provide the indemnity bond to the bank, and bank will issue duplicate fixed deposit receipt. Okay. So this will secure the bank from any third party claims. Okay, third party claims ये बैंक को सेव कर देता है. ओके, तो इस केस में इंडेमनिटी होल्डर, हु इज द इंडेमनिटी होल्डर? बैंक हियर इज द इंडेमनिटी होल्डर. The bank is the indemnity holder. Indemnity holder is the that person who is the promisee or who is indemnified, जिसको indemnify कर दिया है किसने? Indemnifier ने और the promiser ने. Say for in this example, X here, customer X is the indemnifier, जो indemnify कर रहा है और the promise कर रहा है. Okay, and promisee जो promise ले रहा है, that is bank in this case. Okay, so this was just a brief overview of indemnity. What is indemnity? So let's move to the theoretical aspects of the contracts of indemnity. Okay, so let's see a brief introduction of the contract of indemnity. Contract of indemnity is a contract by which one party promises to save the other from the loss likely to be caused to him. Okay, here what happens? Mr. X promises the bank. Mr. X promises the bank to save him the loss that the third party cannot claim him. Okay, that duplicate FDR or that particular FD account belongs to Mr. X. Here X provides the guarantee, a kind of a guarantee. Okay, this loss can be either by the conduct of the promiser himself or by the conduct of any third person. Okay, this loss can be generated by either by third party or either by the misconduct of the customer X. Okay, the promiser is called the indemnifier. Here the promiser, who is the promiser? X is the promiser. So this, in this case, X is indemnifier. Okay, X is indemnifier, and the bank is indemnity holder. He would the bank would hold the indemnity bond and provide the duplicate fixed deposit receipt to the customer X. Okay, the essence of any contract of indemnity is that the assured must prove a loss. Okay, now let's move on to the next one. The rights of the indemnity holder. Indemnity holder means, in our example, it is bank. Okay, let's see the rights of the indemnity holder. In this case, only the 4 points you have to remember. The bank, the rights, what are the rights? That is, he can claim all the damages. Okay, please note this. He can claim all the costs. He can claim all the sums, and he has the right to sue. The bank has the right to sue. The bank has right to claim all the sums and all the cost and all the damages. Okay, let's read a bit. All damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies. Okay, next देखते हैं. All costs which he may be compelled to pay in any suit if in bringing or defending it he duly followed the indemnifier and acted prudently had there been no contract of indemnity, or if the indemnifier authorized him to bring or offend the suit. Okay, all sums paid in the compromise not contrary to the indemnity. Okay, bank has all these rights to claim in the example, and also the right to sue for a specific performance. The indemnity holder is entitled to sue for specific performance if he has incurred absolute liability and the contract covers such liability. Okay, yes, the bank has the complete right to sue for a specific performance in case the contract covers such liability, or such particular conditions that are those are written in the contracts during the contracts. Okay, let's see this. All insurance contracts are the example of contracts of indemnity because all insurance contracts are the contracts which indemnify a person from certain losses. Okay, in case of house loan, in case of house loan, suppose here is the Sunil. Sunil has a house. Okay, he pays the premium to the insurance company. Okay, insurance company pays the premium to the insurance company. Uh, in lieu of these premiums, insurance company provides him the indemnity, a kind of indemnity assurance. In case of in lieu of premium, the insurance company provide the Mr. Sunil the assurance that in case of loss, the insurance company will make the all the losses good to Mr. Sunil. Okay, which he may suffer, which let's read it a bit again. All insurance contracts are example of contracts of indemnity because all insurance contracts are contracts which indemnify a person from certain losses which he may suffer. Example, under a fire insurance policy taken by a shopkeeper for his go down. Okay, the insurance company undertakes to pay a certain amount to the policyholder, that is the shopkeeper or the house owner. Okay, in the event of fire in the godown, subject to the conditions of the policy and payment of the premium by the shopkeeper or the house owner. Okay, now let's see the implied indemnity. Okay, next is the implied indemnity. Let's see it. An implied indemnity is an act is done by one person at the instance of another, and such an act is not in itself manifestly tortuous to the knowledge of the person doing it. Okay, and such act turns to be injurious to the rights of a third person. The person doing it is entitled to an indemnity from him who requested that it should be done. Implied indemnity का एग्जांपल देखते हैं इसी डेफिनेशन के बेस पे. द कोर एग्जांपल ऑफ दिस टाइप ऑफ इंडेमनिटी इज द मास्टर सर्वेंट रिलेशनशिप. Okay, whenever the implied indemnity question comes, your mind should strike at the master servant relationship. Okay, master servant relationship में होता क्या है? The master is liable completely. Who is the liable in such relationship? Master is liable to indemnify his servant. Okay, the master will indemnify the servant for the losses that the servant incurred while working as per the instruction of master. Okay, the master is completely liable to indemnify his servant for the losses that the servant has occurred that the servant has incurred while working as per the master's instruction. That is written here. That is also the definition. An act is done by any person at the instance of another, and such an act is not in itself manifestly tortuous to the knowledge of the servant. Okay, servant doing it, and such act turns to be injurious to the right of a third person. The person doing it is entitled to an indemnity. Okay, the servant is let me put this example in this definition. The servant doing it is entitled to an indemnity from whom? From the master, from who requested that it should be done. Master told us, gives the instruction to the servant what to do and what not to do. So it is completely the liability of the master that he should indemnify his servant. Okay, there is no written contract actually in case of implied indemnity. Okay, this that's why the word implied. Okay, next let's see in the next, that is the express indemnity. When you compare both express and implied, you will definitely have a clear vision of the expressed and implied indemnity. Express, in case of express indemnity, this is also known as the written indemnity. Okay, in case of implied, there is nothing written in the contract, in a kind of a contract. Okay, there is nothing written, that is implied. That's why it is implied. Okay, but in the express indemnity, this is also known as written indemnity. All terms and conditions of the indemnity are mentioned specifically in a contract. Okay, all the terms and conditions of the indemnity are already written in the contract. The rights and the liabilities of both the parties are clearly set out already in the agreement. And example of such type of indemnity, that is express indemnity, are insurance indemnity contracts, construction contracts, agency contracts. Okay, these are the example of express indemnity. Okay, then comes the enforceability of contract of indemnity. Just give me a second. Okay, the enforceability, there will be the enforceability of the contract of indemnity. Okay, let's read a bit. The liability of the indemnifier. In the our first example, the customer X, who is the customer? X was the customer in our example. That one, he is the indemnifier. Uh, commences as soon as the loss of the indemnified. Okay, who is the party here that is indemnified? The bank was the party. Become absolute. Okay, what it is written? It says the loss of the bank, when the loss of the bank as soon as become absolute, certain or imminent. Okay, the liability of that customer X uh, commences as soon as that loss the bank gonna face. Okay, the liability of that indemnifier, the customer, commences as soon as the loss of the indemnified, that is bank, becomes absolute, a certain or imminent. It is not necessary that the promisee should pay for the loss. Okay, and who is the promisee here? Here is premises bank. This is saying that it is not necessary that the bank would pay for the loss if the third party claims for that fixed deposit account. In our example, if a third party claims for that fixed deposit account, it is not necessary that the bank should pay for that loss. Okay, the bank would claim against the customer, that is X. Okay, so let's sum up the contract of indemnity. Contract of indemnity is entered into when a party apprehends a loss in a particular contract and wants itself to be covered from the losses it may incur. Okay, a contract of indemnity may be express or implied. We had already discussed this. Express or implied. In a contract of indemnity, the liability of an indemnifier is a standalone primary obligation. Okay, in our example, who was the indemnifier? Customer. X was the indemnifier, that is uh, it is the primary obligation. Totally responsibility किसकी होगी उस liability की, that is the customer X. Okay, it is independent from and not contingent on any other party's liability to the indemnified party. Okay, indemnified party is bank. Okay, it is not contingent on any other party or to the indemnified party, that is the bank. The principle of coextensiveness doesn't apply to the indemnities. The principle of coextensiveness, this we're gonna read in the chapter of guarantee. Okay, important है exam point of view से. We will discuss in the next lecture this one. An indemnifier will remain liable under an indemnity in relation to a loss under a contract, even if the underlying contract is void or unenforceable. Okay, what does this mean? This means that here X, that customer, will remain liable under the indemnity in a relation to a loss under a contract, अगर वो कॉन्ट्रैक्ट जो है void है और unenforceable है, फिर भी who will be held liable? Mr. X, that customer will be held liable, that indemnifier will remain liable for the loss that bank gonna face. Okay, bank, in order to isolate themselves, I've already given the example. Bank, in order to isolate themselves from any adverse developments and consequent loss at a later date, obtain indemnity while issuing duplicate demand drafts. Okay, fixed deposit receipts, permitting operation in current account of partnership. Okay, in case of bank, where we face such contracts, in case of demand draft, issuing duplicate demand draft, duplicate fixed deposit receipts, and permitting operation in current account of partnership. Okay, let's see the progress. Insurance policies are contracts which are in the nature of, tell me friends, this is indemnity. There are how many parties in a contract of indemnity? There are only two parties in the contract of indemnity, and the person who is indemnified can recover as well as cost for claiming the damages. That is, yes, the indemnified bank can, in our example, who is the indemnified? The bank is indemnified. He can recover damages as well as cost. I've already told you the rights of the indemnity holder. Out of the 4 points, the damages were one and the cost were one. Other two were, what were those? Those are the all sums. Okay, all sums that are paid in compromise. Okay, compromise. And the last one is right to sue. Okay, right to sue. Okay, for a specific performance. Those were the rights of the indemnity holder. What were those? All damages. Please note this: all damages, all costs, okay, all sums paid, and the right to sue. That uh, that is the rights of the indemnity holder and the person or the entity that is indemnified by the indemnifier. Okay, so this statement is true. Okay, let's have a quick recap. Who is the indemnity holder and who is the indemnifier? Okay, in our example, Mr. X is the customer of the bank. Here, Mr. X lost his fixed deposit receipt. Okay, he comes to the bank and asked for the fixed deposit receipt, duplicate to issue duplicate FDR, fixed deposit receipt. Okay, the bank would ask him to provide the indemnity bond to make the losses good. In case in future, if a third party claims against that particular FD account, bank can also claim against the customer X as per the terms and conditions set in the indemnity bond. Okay, so in this case, the bank is the indemnity holder and indemnified. Bank is indemnified person entity. Okay, please remember this. You can remember through this example. Okay, and the customer is the indemnifier or the promiser. The bank is the promisee. I've already told who is the promisee and the promiser. Promisee क्या होता है? Promisee जो promise ले रहा है. Okay, and the promiser who is making the promise. Okay, so that was all about the contract of indemnity. Thank you, and please do like the video.